Is this Mr. Pollins who's coming out?
Yes.
He's the guy with 1,000,000 years of probation. Okay. Hey, Mr. Pollins. All right, come on up to the podium, please. Hi there. All right, how are you?
Who's the gentleman that we're taking that monitor?
Position 15.
Thank you.
Ms. Davis, are you ready on position 7?
I am ready.
Doing a great job pivoting with these. Then let's get on the record. This is 25 SC 001-498, State versus Dantrellis Pollins. Mr. Pollins is here with Ms. Rios and Ms. Davis is here for the state. Mr. Pollins, my understanding is that you are ready to enter a plea in this case and will also handle a revocation in another case you have. Is that correct?
Yes, sir.
Okay. Ms. Davis will put you under oath and ask you a bunch of questions about your rights as a criminal defendant. You need to answer those as best you can and let me know if at any point you've got questions of your own. Will you do that?
Yes, sir.
Thank you. Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name for the record.
Dantrellis Pollins.
Can you spell your first name?
Dantrellis.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
How old are you and how far have you gone in school?
I'm 48 and I had got a GED.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? Possession of a Schedule II drug, willful obstruction by violence, a drug object, and another obstruction charge.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Rios, about all the facts and circumstances known to you about this case, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you remember, Ms. Rios, do you waive formal reading of the indictment and any
Yes.
defects therein? Thank you. Mr. Pollins, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Pollins, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For the possession of a Schedule II substance, which is methamphetamine, the minimum is 1 year, the max is 15 years. For willful obstruction, the minimum is 1 year, the max is 5 years. For a drug object, it is 12 months. And for willful obstruction, it is 12 months.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea today, that you have the right to withdraw that plea?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by you, by your attorney, or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you
Yes.
understand that?
Yes, ma'am.
You understand that you may have only a limited right to appeal this guilty plea conviction.
Yes, ma'am.
You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, ma'am.
How do you plead to indictment 25 SC 001498 to possession of a Schedule II substance, willful obstruction by violence, drug object, and another count of willful obstruction?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes at trial, we would prove that on November 9th, 2024, at 232 Forsyth Street in Atlanta, Georgia, in Fulton County, this is, I believe, the Greyhound bus station, that an officer was on patrol at the bus station. He noticed the defendant, Mr. Pollins, standing outside the front entrance, what he perceived to be weighing drugs. He observed a scale, and then the officer made contact with the defendant. There was a scuffle for the arrest. Mr. Pollins did not listen to the lawful commands of the officer. A taser was drawn, but eventually they were able to secure Mr. Pollins. They did locate a crystal-like substance that was confirmed by the GBI to be meth. And so with that, it's my understanding that the defendant has been in custody, I want to say over 200 days.
209.
And so we are asking for the sentence to reflect 5 years of 200 days, the balance on probation. One of those conditions of probation being his participation in and completion of the Hope House program. Because the Hope House program incorporates a drug and alcohol component, which we believe that is an issue here, we are not going to add that to the sentence because that is a part of the program. We are also asking that the court order that he stay away from the Greyhound location without a lawful purpose, AKA a ticket. And that is it for the state.
Can you give me, I was doing the math on how much time he's been in. It's Hope House, stay away from Greyhound, absent a ticket. But what was the amount of time, probation or time to serve?
5 years, with 200 of those days being in custody.
Okay.
And we are doing a downward departure from the minimum required time by consent. Because I think that the minimum is like a year.
For which,
For for the methamphetamine and for the willful violence towards the officer, there was a scuffle.
oh, okay. But I think those are probatable anyway, so I think we're good.
Yeah.
All right, thank you. Ms. Jackson, if you have any criminal history information on Mr. Pollins, I would appreciate it.
Yes, sir. There are 35 cycles. The last arrest was August the 10th, 2022, with the City of Atlanta Police Department for possession of marijuana less than an ounce and possession of Schedule 1 or 2 controlled substance and possession of Schedule 1 or 2 controlled substance with the intent to distribute. Those charges were dismissed on October the 27th, 2022. He does appear to have prior felony convictions, one in 2010 for obstruction of an officer and entering an automobile, one in 2012 for theft by shoplifting, one in 2008 for possession of cocaine with the intent to distribute, one in 2005 for for possession of cocaine with the intent to distribute. There's an additional one in 2005 for possession of controlled substance. It's one in 2002 for theft by receiving stolen property, one in 2001 for entering an automobile and theft by receiving stolen property, and one in 1999 for theft by receiving stolen property. There are misdemeanor convictions and a sentence. It's one in 2018 for giving false information to an officer and obstruction of an officer. And he received a nolo contendere sentence in 2013 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Well, that was plenty. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Pollins is 48 years old. He's from Atlanta. He has a fiance and stepchildren, ages 14 and 15. He is fully blind in one eye and partially blind in another eye. He was trying to break up an altercation and he was wounded during the process. He's trying to get disability for his eyes. He has a strong addiction to meth that he's been dealing with for years. I have gotten him we've gotten him accepted to the Hope House program. He's been very adamant since the start that he wanted some type of program. And I do believe, since he hasn't had anything like that before, that with the help of this program, this could kick his drug addiction. And he just wants to get on disability and be able to be a father. I believe he has a child on the way. And so he wants to turn his life around to be there for, I think this will be his first biological child. So he can support her. His fiance has been very involved. She calls me all the time, calls Miss Ross all the time. And so she wants him to be there for the birth of his child.
All right, let's talk about that. This hearing featured Judge McBurney presiding over the case of State versus Dantrellis Pollins, a name that, according to the opening, comes with quite the history. Mr. Pollins stepped up to the podium alongside his attorney, Miss Rios, ready to enter a guilty plea to several charges: possession of a Schedule II substance, methamphetamine, obstruction by violence, possession of a drug-related object, and a second count of obstruction. Judge McBurney, as always, kept things orderly, professional, and surprisingly smooth considering the stack of charges and Mr. Pollins's extensive record. He showed his usual fairness and a touch of dry humor when double-checking sentencing math and clarifying downward departures. No nonsense, but never rude. Miss Davis, representing the state, efficiently walked Mr. Pollins through the plea colloquy, covering all the constitutional rights he was waiving. And credit where it's due, Mr. Pollins answered every question clearly, respectfully, and without hesitation. No attitude, no deflection, just straight answers. For someone with what we later learn is a lengthy record, 35 cycles long, his courtroom demeanor was surprisingly composed. Miss Rios, the defense attorney, brought humanity to the forefront. She made a strong plea for leniency rooted in Mr. Pollins' personal circumstances. We learned he's 48, visually impaired, and battling a long-term addiction. She explained that he has a fiancée, 2 stepchildren, and a baby on the way. Her pitch was that this plea deal, which includes a referral to the Hope House program, could be the turning point he's never had. And here's where things got compelling. Unlike many courtroom pleas that feel routine or obligatory, there was a genuine sense that Mr. Pollins wanted help. He pushed for a program, and they got him into one. Hope House, with its drug and alcohol component, seemed like the court's way of balancing accountability with an actual shot at rehabilitation. There were a few moments of dry amusement, like when Judge McBurney asked for confirmation of the math on time served. I was doing the math on how much time he's been in, a subtle nod to just how many moving parts this case had. Miss Jackson's rundown of Mr. Pollins' record was extensive, including prior felonies dating back to 1,999. But even then, the courtroom didn't shift into judgmental territory. Just facts, handled with professionalism. The courtroom atmosphere stayed calm and focused throughout. No drama, no outbursts. Just a team of legal professionals, judge, state, and defense navigating a complicated situation with care. And really, that's where this hearing stood out. It was thorough, balanced, and dare I say it, hopeful. The state agreed to a 5-year sentence, 200 days served, already in custody, and the rest on probation, with a strong push for Mr. Pollins to complete Hope House. Oh, and one more condition. Stay away from the Greyhound station unless you've got a ticket. A very specific, very reasonable term given the circumstances. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.